related to that. This, of course, concerns the defense motion that was filed last Friday regarding the jury questionnaire process. I want to focus, at least for the time being, on the request to close a portion of today's proceeding. My response after the state indicated it would not be objecting to that request, my response then, which I'm sure the parties saw on CCAP, I also had my clerk email the parties, concerned the following. Number one, if I were to grant this request in part or in full, what is the state's request as it relates to victim access? And then the second part of that is really to talk about alternatives to closure and whether closure is even appropriate. And then, of course, the other parts of the what I will refer to as the Waller criteria. So first, let me ask the state if you've thought about victim access and what the request would be if I were to close part of the hearing today.
Yes, Your Honor. It was actually discussed between the parties before the filing was made by the defense. I believe there's agreement that the victims can be present and participate, well, I shouldn't say participate, but observe the proceedings, and that the request would be just to close it to the general public and the media to avoid potentially contaminating the jury pool. So and I apologize because that was not in the filing by the defense, nor was that covered in my reply. And it was, we had a meeting of the minds, but we never conveyed that to you. So I certainly understand the court's concern, and that was a gap in the information that was provided to the court.
If I close the hearing, though, how are they to participate? I mean, of course, I have Zoom. That's one way. Would they be here in person? Has there been adequate notice?
So, yes, there are some victims here in court today, Your Honor. If I can confer with Ms. Dunn, I don't know if any are intending to live stream or Zoom or participate virtually, but I know she had mentioned to me yesterday that generally speaking, the interest from the victims in this hearing was lesser than for other hearings. Probably it's just not that thrilling of a topic for them, but let me check with her, please.
Please do.
Okay. Thank you, Judge. We were not alerted by any victim that they intended to watch via the live stream. However, they certainly could have jumped on and we don't know it, and there's no way for us to know. I don't know if the court can tell that. The court cannot tell that.
No, I cannot
Okay.
tell who is watching
I see.
the live stream. Like, it was different with
Zoom.
Zoom I could, or even when I live stream in the past through YouTube, I could see at least how many viewers there were. I'm not able to do that with the daycast.
Okay. So I guess that would be our request then, if the court should grant the motion to close it, then we would go to a secure Zoom link where the victims could be notified of that in relatively short order. Yes. And, we might need 5 or 10 minutes to get that accomplished, but we would ask them to switch to a secure Zoom link.
All right, and on behalf of the defense, can you just confirm that there was no or is no objection to, again, if I grant this order in part or in full, for any victims to appear by Zoom or be in the courtroom.
That's correct, Your Honor. We do not object to victims being present in however works best for them.
What about any family members of Mr. Brooks or anyone else on his behalf? Are you aware of anyone who would want that kind of access?
We are not aware of anybody offhand that would want that kind of access. If I could check with Mr. Brooks briefly and see if he's had a chance to check with his family at all. Yes, we would be able to provide to them a secure Zoom link as well.
All right, thank you. That, of course, as I've said, and I'll probably state multiple times, it's a big if at this point, whether I close this hearing. So I want to talk then about the Waller criteria. I know the parties are well aware of that. It's the criteria that is referenced in the Pino decision, which is the Wisconsin Supreme Court decision, the most recent decision related to this issue, and that's found at 2014 Wisconsin 74. Criteria the court needs to look at when considering a request or whether on its own motion to close a courtroom proceeding to the public in a criminal case without violating a defendant's public right to trial. And I would also add the public's right under the First Amendment and also a state statute that's relevant. The court must ensure the following four requirements are satisfied. Number one, the party advocating for closure must advance an overriding interest that is likely to be prejudiced. Two, the closure must be narrowly tailored to protect the overriding interest. Three, the judge must consider reasonable alternatives to excluding the public. And four, the judge must make specific findings to support the exclusion of the public so that a reviewing court may assess whether the courtroom was properly closed. And while that's a citation, or I'm reading from the Pino decision at paragraph 45, that is a citation to the U.S. Supreme Court decision in Waller, which is 467 U.S. At pages 45 and 48. So with that, this is a request by the defense. I know it sounds like the state's not objecting. I don't know if it's a joint request. I wasn't clear on that from the filings. But my question very squarely is, what is the overriding interest that is likely to be prejudiced by having this hearing conducted in a public fashion?
The overriding interest is the constitutional right to a fair and impartial jury trial. And if the potential jury pool is allowed to hear all of the conversations that we may be having, and I don't know exactly what all the conversations are that we're going to be having regarding these jury questionnaires. They are relatively similar overall, but if we are going to be discussing in detail the contents of the questions, we've submitted them under seal. We're asking that they be remaining confidential with the jurors. It defeats the whole purpose of all of those confidentiality markers that we've been discussing from the beginning.
I'm going to need a little bit more, I guess, on that analysis of why you think it defeats the purpose of the confidentiality when, as you point out, these proposed questionnaires are very similar by the parties. I don't even know at this point whether there's any objections to any of the questions and what those are. And I don't know that talking about them, either referencing them by number, for example, and whatever the objection may be, the process by which we summon the jurors, right? There's some confidentiality associated with that by statute. But I don't think just having a general discussion about the process and even having it reported on defeats any purpose of these questionnaires. So again, I need to be convinced that there, number one, is an overriding interest that is likely to be prejudiced with an open court hearing. Is there anything else you can tell me or argue to me on that point? I can ask the
Judge,
state. Oh, go ahead.
If I could, part of this is from, in looking at the samples that were provided, the advisement to keep these questionnaires confidential, to not share them. So the inevitable reporting, broadcasting of what the questions are, the reasons behind them, that would undermine that guidance, that instruction that's been given in the past to jurors, which I think is consistent with the reason these are under seal by the court right now. And traditionally, questionnaires, I think, remain under seal. The alternative that was suggested by the court, we're also fine with, in terms of just to obviate any need for really finessing which part of the conversation is under seal. It probably, looking at the two questionnaires that have been proposed, isn't going to be that difficult of a conversation. And if just hashing it out, not in court, and then coming back and submitting what's been agreed upon, and if there is any disagreement that has to be put on the record, then it would be a very limited closure that we'd be asking for, just be as to that. So it really is just the integrity of the process, consistent with what's been provided to the parties by the court in terms of past examples, and just consistent with the reason these questionnaires are sealed in the first place.
I can tell the parties, I took a look at what my colleague, Judge Boren, did in the Slenderman cases, and those discussions were all on the record. Now, the parties in that case did make a joint submission, so they did meet and confer before that hearing. But even at that hearing, there were very little discussion. I want to say it was a 17-page transcript where things like, for example, in one area, the questions referred to immediate family, and in another area, the question said family. So there was a discussion on how to make that uniform, and should it be immediate family or family. I can tell you, for example, in my review of these questionnaires, right, there's use of the word spouse/partner in areas, and then use of the phrase spouse/significant other. I'm not giving away anything as it relates to the question, but it's a good question because we want uniformity in how these questions are asked. And the confidentiality and the admonition to the jurors is to ensure that they are free from influence. Anything they've seen or heard, they're going to report to us. So in my perspective on all of this, they're going to tell us whether they've seen anything, and we could even add something in the questionnaires that says, they are to avoid, watching any proceedings or reviewing any news reports going forward. That is something that could be added to the instructions with the agreement of the parties. Let me ask the state, though, because I want to give them an opportunity if they have anything to add in terms of what you believe the overriding interest is that is likely to be prejudiced, since I believe you are joining in this request.
We're not objecting to it. I don't know if that distinction is important or not, but essentially, to be frank with the court, one of our concerns is that this issue was spun out of the change of venue motion, and to the extent that the state's participation in pretrial publicity is a factor, we're erring on the side of caution, right? Really, to us, of course, we respect the public's right to know. No matter what we do on this case, it will be reported on. So closing the hearing, not closing the hearing, there's going to be a story about it on tonight's news, most definitely. But to the extent that we want to do everything we can on behalf of the state to ensure a fair trial for Mr. Brooks, and if his counsel feels this assists in that regard, then we don't want to stand in the way of that, Judge. So that's essentially our logic. I think I agree with the defense that, you know, the more we talk about things in an open courtroom to the general public, that may spur interest that wasn't previously there. Maybe now somebody decides, I'm going to go look this up, or what's this about, on a certain topic that we may be discussing in the jury questionnaire. So in an effort to prevent tainting a potential jury pool further, I think there's some value in that. I don't see, and point number 3 about reasonable alternatives, I don't view that as preferable because of the victims. So if we all go into chambers and hash this out and then come back on the records, the victims can't participate in that. If you send the attorneys out to come back later today, tomorrow, next week, and hash it out, the victims don't get to be present and observe that. So I would argue that's less preferable than a closely tailored order by this court that when it comes to discussing the actual questions and the content of the questions, that for that limited purpose, the live stream is turned off to the general public and the media is excluded from the courtroom. As far as I can see, Judge, there's generally not any general public in the courtroom, but that can be assessed as well. So essentially, that's our position. We're not objecting because if the defense feels it's important, we don't really have a strong position on that. We want our citizens in general, of course, to be aware, but we don't feel that closing the discussion on the content of the questions is such a significant right to the public that it should outweigh the rights of the defendant to a public hearing. And it is a pretrial hearing, Your Honor, and a very narrow issue that we're going to discuss. So,
And I appreciate that as well. I want to back up just a little bit, and why I ask all these questions is not really, or not only because of the Waller factors. We could probably have a pretty vigorous debate about whether a pretrial proceeding has the same protections as a trial that's open to the public. But I've reviewed extensive case law, not just within Wisconsin, but the United States Supreme Court, and even outside of our jurisdiction, some other federal cases. And Wisconsin is a little bit unique in that, in addition to, you know, the constitutional protections, which we all talk about, we've referenced the right to a fair trial, it's the right to an open trial as well. That's the 6th Amendment, which has been made applicable to the states by the 14th Amendment. There's also the First Amendment right, and that's the public's right. And we also have, as has been referenced, now we have Marcy's Law, where the victims have a right to participate or be present for all proceedings. Again, we could probably have a large debate whether requiring the parties to meet and confer is a proceeding that they'd have a right to attend. I tend to think not, because it would be outside of the court process, and it's certainly something that is required in many cases. I require parties to meet and confer about issues, even including jury questionnaires or jury voir dire question. That's part of my standard trial order. We also have a statute in Wisconsin, and that's 757.14, which requires that the proceedings be open to the public, and that has about 150 plus years of history. The original statute goes back to 1849, and it was Chapter 87, Section 17. And so the right to a public trial and the right for the proceedings to be made public is firmly embedded in our process in the state of Wisconsin. I would argue that it extends to all parts of the criminal trial, whether it's pretrial, trial, or otherwise. This is, again, a very nuanced question because we're talking about jury questionnaires. The case law is very clear that the right to a public trial also extends under the Sixth Amendment to issues of jury selection. And while pretrial, again, we're talking about that process, so I would argue that it also is applicable under that as well. There's a really good paragraph in the Pino decision. It's paragraph 78 that talks about fairness, and this is what it says, and I think it's worth stating on the record, and that is, fairness is essential to our system of justice. This fairness should be a pride of every court. It is hard to demonstrate this fairness if the courtroom is closed, if citizens who have done nothing wrong are shooed away. A judge should respect the importance of the duty to facilitate justice at every stage of the proceeding and should exercise great care that no rights are violated. To again quote my colleague, Judge Boren, he takes the sunshine approach, and I think that's a really good way of looking at it, and I like that approach as well, and that is nothing that we do here is secret, right? We shine light on everything that we do because we want to ensure fairness. Fairness for Mr. Brooks, fairness for the state, fairness for the public and the media who clearly has an interest in these proceedings. That is not to say that is an unfettered right, whether I look at all of the cases that deal with the First Amendment right, the Sixth Amendment right, or even in Wisconsin, our statute. It is very clear that a court does have authority to close a hearing. That is why I started this hearing with really asking the parties, what is the overriding interest that is likely to be prejudiced? What I have heard from the parties is that, call it the integrity of the process, the confidentiality of these questionnaires, the pretrial publicity that's surrounding this case and this topic. Those are all important parts of our system and incredibly important for this case that has garnered such pretrial publicity. But if I were to look solely to those things, I could make a finding in any case that closure is important. So it must be something more. The cases talk about it being a compelling interest. And even if there is that compelling interest, it must be likely to be prejudiced. And at this stage, I think we're talking in hypotheticals. It's speculative for this court to say, we will taint the jury, it will not be confidential. And I say that because these jury questionnaires, ultimately, when they go to the prospective jurors, come with a very strong admonishment and admonition that the jurors themselves, these prospective jurors, keep this information confidential. The point behind all of that, I should say some of the points behind all of that, are that number one, we encourage jurors to be truthful, to be open, to be honest, right? That is what a questionnaire in part does. It helps us evaluate their exposure to the pretrial publicity, to victims, to witnesses, to the parties in this case. And it helps streamline the jury selection process, ultimately, that we all hope to get to in October. Keep in mind, if I did no questionnaires, all of these questions would be reasonable to be asked and would be done in open court. We do that all the time. I have a script I follow with the more sensitive questions. I think we've gotten better as a system in addressing jurors with sensitive topics so that they aren't providing, more information than they are comfortable providing in an effort to uncover whether they have any potential bias and they're appropriate to sit on a case. So I think we have to keep that context in mind when I'm asked to close a proceeding that in probably 95%, if not higher, of the cases that come before the court, all of these things would be in open court to begin with. Even if I find that all of the things that I've just cited, right, the pretrial publicity, the confidentiality of this process, etc., together equate to an overriding interest, that this closure must be narrowly tailored to protect that overriding interest. I have proffered to the parties what I believe are some reasonable ways to keep this process confidential, and while limiting the information that we discuss in a public venue, by requiring the parties to meet and confer and submit then a joint submission to the court. And even if there are objections to any of those questions, if there's just something that a party wants that another party objects to, that can be submitted in writing under seal, and even the contrary position under seal for the court to consider, so that when we do have that public hearing, it is limited so that, again, the confidentiality of the questionnaires themselves, the reasoning behind the questions, the publicity associated with all of that is kept to a minimum. I understand the state's position that it would limit, victim access, but because it would not be in open court, it would not, in my opinion, it would not be a proceeding. But I'm certainly open to further suggestions if that is something the parties would want the victims to at least observe. Whether that's, for example, providing a courtroom for the parties to do that. Mr. Brooks could be part of that as well, the victims, but the court wouldn't be here, really just providing the venue and then victims could observe. I don't know if that's something that is needed, but again, I'm trying to come up with the alternatives because I am required to do that under the case law. State have any position on that?
Well, again, Judge, we're not objecting to this request. I think I understand where the court is heading in its ruling here. I would just like to make two observations, please, because to the extent these may be relevant. I also read a lot of the case law. I have some personal familiarity with the Slenderman case because I was the DA at the time. None of these cases involve mass casualty, which is the allegation here. And I think that is a distinction that should be noted, is that Slenderman, we had one victim. In this case, we've identified almost 100 victims and thousands of witnesses to this event. So I think there's a little bit different approach that the court can take when you're speaking about, if this is the standard, we would do it in every case. First of all, defendants don't request this in every case. This is highly unusual. I think in my career, this is the second time I've ever even had a request by anybody to close a hearing. So this is very rare and very unique. So I'm not concerned that this would somehow lead to closed hearings on every event. We certainly understand that these questions will very likely be asked again during the actual voir dire process to some extent, because things will change between the time when the questionnaires are completed and when the day of trial. But we're not objecting to that. I think the concern, and I'm not going to speak for the defense, but the concern is to not taint the pool of potential jurors at this stage. If they're sitting here in open court and we're asking these questions because this is the day of trial, that's much different than doing it 6-7 months in advance of the trial, in my opinion. So I just want to make that distinction again so that it's considered by the court and we're not litigating this, potentially some point down the road. I would just note again, Your Honor, making an observation, and this is my observation of the courtroom. There's nobody present in this courtroom other than a few victims, 3 or 4 victims, some members of court staff, some attorneys, a member of the press, and perhaps 1 or 2 other people that I don't know. This hearing, I don't know how many live stream participants there are, or if that can be determined, but every hearing there seems to be less and less interest in this case, which in my experience is normal. I think that's another factor for this court to consider here today. My only concern, if we don't mesh this out this morning when we set aside 3 hours to do it, is it'll cause delay, right? I mean, if you tell us to go pick a time for the parties to meet and get back to you and file a joint submission, that's all going to add time and delay. And at least my understanding was our goal was to try and get this out like next week. And so maybe we can still accomplish that, I don't know, but that would be another concern. There's not a lot of difference between the submissions, Your Honor.
I agree. And I appreciate the additional factors, and I would add to that, it is a request that was made by the defendant, which is unusual. Many of the cases talk about when a court does this for one reason or the other, and it's the idea that a defendant can waive a right. Again, that's only part of the analysis because the public has a right to be present as well. I would also add, before I ask the defense for any additional thoughts or arguments at this time, the other possibility is just to simply not live stream it and otherwise keep it open to the public. Let me turn to the defense for any additional thoughts or arguments.
I guess of the sort of array of options, I think it would be nice to hash this out this morning. I think that could be done not in open court, since we have the mornings cleared on our calendars to work on this. I think that if we were to break for an hour and come back, we could probably have kind of a general joint submission. That'd be what I would suspect. The live stream aspect of this, of course, is right. It doesn't really matter how many people are present in this physical room. It's that it's being, recorded and sent everywhere. The other sort of distinction in terms of the court's explanation and analysis of this is not really, I think, a substitute for what's going to happen with the voir dire eventually, because this suggestion, which was made by the state, is in response to supplement the change of venue motion. And so in terms of all of these questions will eventually be asked in open court. That may be so, but that's not really the lens right now. I think this has to be looked at through the lens of that this is in the change of venue motion. And so I think that that's a distinction in terms of what's the point of these questionnaires right now.
I would, from my perspective, the purpose of what we're doing now is in part related to the change of venue, but it's also for all of the reasons we talk about when we do jury questionnaires. And doing it ahead of time in such a case as this is, I think, just smart process because of the time and the energy and the resources involved.
There's something else I should put everyone on notice for right now, and it's today is, what is it, March 29th. It's true that at the last hearing, which was the first hearing before this court in this case, and right now this trial is scheduled for the month of October, and the month of October is open in our calendars, but subsequently in looking at going back, assessing the array of expertise that we need to consult and the sheer volume of discovery that is that we've received, and the discovery which will be complex that we have yet to receive. The October trial date is likely very unrealistic for us to be prepared, and wanted to, it's early. It's as early as we can notify the court of that, and I think it's probably better to address that now than in August or September. Already with these, I think the initial letter that went out talks about the date of October and things like that. And I don't know that that undermines the purpose for these questionnaires, even at this early stage, because of the change of venue issue that needs to be decided. At the last hearing, there were a couple of dates that were thrown out. There was the October date, and then we talked about into 2023. It's, and I apologize in terms of any inconvenience. We're really trying to minimize that by bringing that up right away. But before we get too much further in this, and even with these questionnaires, and some of the advisements and talking about time set aside, it is very unrealistic that we would be fully prepared by October.
I appreciate you putting the court and the parties on notice of that as well. Just on the last, well, two things. You talk about the purpose of the jury questionnaires, and yes, it is to help us assess the change of venue, to supplement, as you said. I think that's a good word. I came up with some other reasons. I've named some of them, but I just found my list, so I want to put all of that on the record as well. Of course, to streamline voir dire later on, to provide a forum for potential jurors to answer truthfully. It promotes openness, honesty of those potential jurors. It assists the court and the parties in assessing the jurors' exposure to publicity, any parties, victims, witnesses, and to identify those for the court. The last thing I would add is I also looked at the size of the master list from which jurors are called in Waukesha County, and I think that's a relevant criteria. Number one, we're a county, the size of which is around 400,000. I don't have the exact number, but that's generally speaking. The master list is for 2022 is anticipated to be over 314,000. So that's the number of potential jurors from which we select from each year. So that is the list that the Director of State Courts office puts together from the Department of Transportation records. I can just tell you historically those numbers have been in 2018 it was just over 306,000, 2019 just over 308,000, 2020 311,000, a little bit over, and then in 2021 just over 315,000. So quite a lot of potential people to pull from for a jury where, of course, at the end, we will need 12 to deliberate. Number of alternates is up for discussion, whether it be 4 to 8, as I've seen in some other cases.
Judge,
So-
I do know.
Oh, go ahead.
I'm sorry.
No, go ahead.
Thought you had. There is one reason. I think the most significant reason that we haven't been talking about this in aiding voir dire eventually is because, of course, we believe that venue should be changed, and so that's why we've been talking about it in the sense of the limited purpose of aiding in the change of venue motion.
Understood. Thank you. So just to, I guess, bring us back full circle to the request that I close part of the proceeding today, as I've already indicated what the Waller criteria are. As has been mentioned, closure of a proceeding is the exception, not the norm. It is something that this court should do only in rare circumstances. I am mindful that in this particular case, it is a request of the defendant. Closure that has been requested, I would also characterize as not being trivial. It is something that would involve closing it to the general public, to the press, and limited to the parties, victims, and perhaps family members of Mr. Brooks if they so choose. Jury questions generally are open to the public. We've talked about that in the voir dire process. And what these questionnaires are seeking under the statute, meaning the jury statute, which is Chapter 756, we're seeking supplemental information from potential jurors in order to, as we've already stated, look at the issue of jury selection, but also a very important consideration is to help assess the appropriateness of the change of venue motion and to kind of gauge the publicity here within Waukesha County. I think it goes without saying, but I'll state it in any event, right? The Constitution, the statutes all require, right? The starting place for venue is the county in which the alleged criminal acts occur. For purposes of today's hearing, even if this court were to find that there is an overriding interest, a compelling interest, I am satisfied that there are alternatives to closure that can meet the interests that have been so identified. And that is to require the parties this morning to meet and confer outside of this court hearing and make a joint submission to the court. If there are any particular questions that a party desires that the other party objects to, I know the parties are well aware of how to e-file and can simply file a letter request under seal that I will consider today and decide. I will take under advisement at this point whether once we have that joint submission and there are any discussions that need to be had on the record, whether to close the proceedings at that point. I think that preserves the issues. If I were to grant any closure request at that point, I will be sure to provide Zoom information to both of the parties. It's not the Zoom information that's out on our spreadsheet. I specifically started a special Zoom meeting for today's date, so I will provide that. And I would also consider, of course, just perhaps not live streaming at all. That may be the way to do this. But again, I will take that all under advisement. I think we all have set aside a significant amount of time this morning. If need be, I am also able to go into the afternoon. And I think an hour would be sufficient at this point. If you certainly don't need an hour, you can let me know. We'll be available. But my intent right now would be to go off the record, to pause the proceeding and require the attorneys to meet and confer about the submissions with the goal of providing a joint submission to the court that the parties agree with. I do want to just point out a couple of things that don't need to be confidential that I did, and I've already mentioned a couple of them. It would be use of consistent phraseology, things like whether it says spouse/partner, should it say partner or significant other? If there is reference to family members, should it be immediate family members, so that it's consistent in that regard. Please make sure you also are prepared to tell me whether the letter that the court sent to the parties, it's a letter that would ultimately come from our clerk of court, Monica Paz, but it has, and then the instruction page that she drafted. I know the state had an instruction page on there, but I would, similar, but I would, at this point, intent on using the one that she has drafted. And then lastly, should the questionnaires list all victims and potential witnesses? That's something that wasn't done. So I will leave that to the parties to discuss. My intent would be to reconvene at 10:45. Anyone want to be heard on that? From the state?
No.
From the defense?
No.
Do you have any request to do that in this courtroom, closed to everyone, so that Mr. Brooks can be part of that, or just the attorneys?
It doesn't matter to defense.
This is,
And we can do it in a conference room, please.
all right, then,
I guess it'd be good if we could be in here and Mr. Brooks could stay with us, if that's possible.
all right, then that's what we will do. I will momentarily be shutting down the live stream. I have to wait 15 seconds or it cuts off from where we were at, so I'll be mindful of that. Since it will not be a court proceeding, the media room will be closed, the audio will be turned off, and everyone else will be asked to leave other than security officers, since Mr. Brooks is in custody. Anyone want to be heard on any of those limitations from the defense?
No.
From the state?
No.
All right, then. We are in recess then.